It's a common assumption that when someone dies with property in their name, the property automatically transfers to family members. Texas requires heirs to take some action in order to transfer the property. I see many cases where the property stayed in the decedent's name for several generations until an heir finally took action. Generally, attorneys aren't going to give you free advice, but take this from me. With probate matters, the more time passes, the higher the cost. There are three general options to transfer real estate out of the name of a decedent. The first is probating the will. This, of course, assumes the decedent left a valid will. This option allows the decedent to choose who inherits their estate. The second is an estate administration. The decedent passed without a will, and the court must appoint an administrator that will distribute the property according to state law. And the third, finally, we have the Affidavit of Heirship. This is a document that is filed in the property records and is less costly because it does not require court proceedings. Let's focus on the third, least costly option, the Affidavit of Heirship. As stated already, this option does not require court process or approval. The affidavit is a form that is filed with certain required information in the county land records. If all the information is properly on the form, then the affidavit acts like a deed transferring the property from the decedent to the heirs. Now you may be asking, if it's so simple, why would this option not be used all the time instead of costly court proceedings? Well, as in most things in law, it's just not black or white. For example, the decedent may have left other assets besides real estate. In this case, an affidavit of heirship may not work because they are only intended for real property. If there is a mortgage on the real property, an affidavit of heirship alone may not allow you to discuss the mortgage with the lender. Unlike a court order, an affidavit of heirship is not required to be accepted by title companies, banks, or other third parties. Now, I don't want to cause alarm because in most cases the affidavits are fine, but one should know the law does not force third parties to accept the document. If the affidavit of heirship is not correct, it could cloud the title on the property, causing more problems for the heirs. And lastly, affidavits of heirship can be misused by people involved in fraud and forgery. Long story short, affidavits of heirship are simple, cost-effective, and most importantly, quick. The reason that I have covered some of the potential issues is that I want to stress this. It is important to use competent legal counsel when using this option. Affidavits of heirship are not do-it-yourself projects and can cause more harm than good. If you or anyone you know needs to discuss whether an affidavit of heirship is the right legal option, please contact our office immediately, and I promise you, you will receive prompt attention. Thank you for watching.